Hello everyone. Welcome you all to Sunya IAS. Welcome back to Top 50 Rapid Current Affairs of each month, starting from the month of May. Here we discuss the most important high-yielding topics from the current affairs that is very much useful for your prelims examination, Civil Services 2024. I hope your preparation is going really good. How this program has been designed, that each month's current affair is divided into 5 parts. And how do we complete it? 1 to 5, 1 month completion of the current affairs will be done. 11 to 15, another month's current affairs. And 21 to 25, the next month's current affair. We have started from the month of May and simultaneously other things have been completed. You can watch from the playlist of TFR. 1st April, we have done economic development. 2nd April, polity, governance and international relations. 3rd April, environment and ecology. 4th, science and technology, then reports, indices, defense, art and culture, and miscellaneous topics like government schemes will be covered. Here you can see already that so many questions are being asked from international relations, environment, and science and technology. They have huge weightage in the new pattern of the UPSC. So, our focus here is to understand the context through previous year questions. They are the beckoning light that what kind of questions are being asked in the UPSC examination. You can also join the current affairs crash course, which is already live on www.sunyaias.com, and the offline batches are there in the Delhi center. In the offline mode also we are doing current affairs crash course. First batch started on 19th March. Second batch started from 1st April. And soon third batch is going to be launched for the current affairs crash course. You can do join that only at Delhi offline center. So without further ado, let's start. First topic is J&K Reorganization Amendment Act 2023. The revocation of Article 370 done by the Union government. Leaving aside all the controversies, let's understand what kind of questions can be framed from here. From the polity static portion, you would have definitely studied that our federalism, India is a quasi-federal state. So we can always show competitive federalism as well as cooperative federalism. Okay, competitive federalism and cooperative federalism. Cooperative federalism means horizontal federalism. Competitive vertical federalism has been shown. First time, the power that central government drawn from the Article 3 of the Constitution, that is, this aspect you do not understand sometimes. Article 3 of the Constitution gives power to the Union for what? For 3 things. The name of the state can be changed, the boundaries can be redefined, or state can be divided into 2 or 3 different states. But the power to extinguish a state and convert it into a union territory has not been given. First time it had been done that the statehood of J&K or any other state has been extinguished and it has been converted into union territory. That pose a serious threat to other states. Getting this point? This is unconstitutional to that extent. Therefore, by giving the verdict for the incremental integration of J&K to the mainland of India, the Supreme Court also noted that the statehood of the J&K must be restored, and election should be conducted by the end of September 2024 itself. So let's see what changes have been done. This particular case had been the case of asymmetric federalism. So UPSC may ask you some definition or concepts regarding what kind of federalism does India have. Increases the total number of seats. It has increased the total number of seats to 114. Previously there were 107 seats, and the 7 seats have been for scheduled castes. Okay, and 9 seats for scheduled tribes. Remember this, 7 seats for scheduled castes and 9 seats for scheduled tribes. Number of seats have been increased. Amendments substitutes weak and underprivileged classes. So now weak underprivileged classes along with the statehood, the special status of the state has not been considered. Statehood, one aspect. Another aspect is what about the special status of the J&K? So here, the definition of weak and underprivileged class is deleted from the Act. It has been deleted. Into the Legislative Assembly, up to 2 members from the Kashmiri migrant community, 1 must be women, and 1 member representing displaced peoples from Pakistan occupied Kashmir. Okay, POK, Pakistan occupied Kashmir and Kashmir. So what changes have been done? Basically, IPC, Indian Penal Code, had been there in the India. They had Ranbir Penal Code. So certain changes that have been affected because of that. Now no dual citizenship. Only one citizenship, that is of India. Central laws can directly be applied over there. Previously, apart from the 3 subjects, other laws required permission or the concurrence of the State Legislative Assembly. No separate laws for J&K. Indian citizens from other states can buy land and property. No 2 flags, only 1 flag, that is of India. Elections every 5 years. This is how we are going to restore the statehood of the J&K. Police will be managed by the center. Financial emergency previously could not be applied to the J&K, but now financial center can declare financial emergency under Article 360. So these changes you have to keep in mind, plus certain basic constitutional or federal features will be important. Sexual harassment of women at work, Prevention, Prohibition and Redressal Act 2013, or POSH Act also it is called as POSH Act. So what happens that this is about sexual harassment at workplace. It is in line with the Vishakha guidelines given by the Supreme Court back in 1997 itself. So it does not count only on the actual sexual harassment at workplace, but also non-sexual harassment at the workplace is also included. The ambit of this act is very wide. But when we talk about its implementation, the Supreme Court has criticized. Internal Complaints Committee has not been formed by various organizations. If women does not have right to complain, what is the implementation part of this act then? So just understand that it is in line with the Vishakha guidelines. What is Internal Complaints Committee? Any organization having more than 10 members or 10 employees must form Internal Complaints Committee presided by a woman at a senior position. There are different criteria for that matter, but the organizations which have less than 10 employees, there we have Local Complaints Committee. It can receive complaints from women working in an organization having less than 10 workers. तो उनके लिए भी इसमें प्रावधान है. There are certain penal conditionalities also. Penalty will be there if you do not form Internal Complaints Committee. So it does not abide by any law and other provision. They must pay a fine up to 50,000 if the employer fails to constitute Internal Complaints Committee. देखो ये बहुत important है for the effective implementation of this law, which increases for a repeated offense. Repeated offense के लिए 50,000 से ज़्यादा भी fine लगेगा. Now, 2 things here you need to remember: the workplace and the employee. The ambit of the definition of the employee is not just limited to the definition of Companies Act, because companies have been formed, organizations, they have been registered in the Companies Act. तो कंपनीज एक्ट में कॉन्ट्रैक्चुअल लेबर के लिए अलग डेफिनेशन है, पेरोल लेबर के लिए अलग डेफिनेशन है, टर्म एम्प्लॉयमेंट के लिए अलग डेफिनेशन है. बट एनी पर्सन into your premises may not be an employee, may not be a direct or indirect employee of that organization. Even if a delivery person has come and she is a female and any harassment has been done to her, that would constitute sexual harassment at workplace into that organization. That is important. So the definition of the employee has a wide connotation, more wider than the Ministry of Corporate Affairs itself. And the workplace. Workplace includes everything. Not just public, private, but NGOs also. Workplace organizations, NGOs, houses. The residential houses will also be included here. Market. Private companies, educational institutions, farms, etc. So workplace, you cannot define that this is the exact boundary. Into that premises, if anything happens, it will be constituted as workplace at harassment. The presiding officer shall be a woman employed at a senior level at workplace from amongst the employees itself. Next topic is Telecommunications Act 2023. It has got president's assent. It is going to repeal and amend. Two things have been done. It is going to basically repeal Indian Telegraph Act and the Indian Wireless Telegraphy Act. Repeal Indian Telegraph Act and Indian Wireless Telegraphy Act, and going to amend Telecom Regulatory Authority of India, TRAI Act 1997. Remember this, TRAI 1997. So these two acts have been repealed and this had been amended. Why the amendment has been done? Basically, this act has been amended so as to allow that minimum 30 years of professional experience is required to become the chairman of TRAI. Minimum 30 years of professional experience and minimum 25 years of professional experience is required to become a member of the TRAI. ये amendment की है. दूसरी important चीज, how the spectrum will be allocated. Two methods are there. Okay, one new method you will get to understand. It is as per the global norms. पहले हमारा क्या होता था? Spectrum auctioning. We always knew spectrum will be auctioned. So that method we are going to continue. Spectrum will be auctioned and hence it will be allocated. Next method is for the administrative purposes also. Administrative method. You will get to understand spectrum for satellite internet providers. We will get to understand this. What else had been included? Now, to provide telecom services, a prior permission from the central government is mandatory. A prior permission from the central government is mandatory. The different kinds of messages, the different kinds of data that we share, that can be intercepted, monitored and deleted if it is found that it is ultra wires to the national security. Therefore, interception, right to privacy somewhere is in the question. So whatever the chattings we are doing, whatever the messages, emails we are sharing on the name of national security, that can be intercepted. And there is one Universal Service Obligation Fund, USOF, Universal Service Obligation Fund. Its name has been changed. Okay, ये Universal Service Obligation Fund, more than 5,000 crores rupees is there into it. Okay, और इसी के थ्रू हम लोग नेशनल ऑप्टिकल फाइबर नेटवर्क भी बना रहे हैं. So its name has been changed as Bharat Digital Nidhi. Bharat Digital Nidhi. Okay, Bharat Digital Nidhi. The question for which a lot of debate happened was whether OTT platforms will be included into it or not. So OTT platforms will not be regulated under the Telecommunications Act 2023. OTT प्लेटफॉर्म्स के लिए डिजिटल मीडिया एथिक्स इंटरमीडियरी गाइडलाइंस अलग से आई हैं. डिजिटल मीडिया एथिक्स इंटरमीडियरी गाइडलाइंस that will be regulating these OTT platforms, that what kind of content is shown. Sometimes vulgar, sometimes violent content are shown which is not good for the children. They are age sensitive contents. Parental lock should be there. There are certain contents that are outrageous, that may hit the cultural fabric of a country. So communal outtones should not be there. For that, these OTT platforms will be regulated by different rules. Now, first time this has been introduced, spectrum for satellite internet providers. What do you mean by satellite internet providers? Starlink project का नाम सुना है? US based Starlink project led by Elon Musk himself. So what will happen? Previously, we used to have satellites in the geostationary orbit. Now, small satellites, more number of satellites will be there for internet service providing. And here in the science and tech part, we have discussed one more thing, that what happens, it contains modem, a different modem is there into these satellites that can directly give internet into the mobiles, handsets. Tower is not required for that matter. Therefore, spectrum for these satellites, internet providers will also be there. Bharti backed satellites are also there. Geo is working into it. So this is in line with the global norms. Next topic is Chief Election Commissioner and other election commissioners appointment, conditions of service and terms of office bill. Here you will find that legislature and executive are fighting for their jurisdiction and are also fighting for their, kind of what is the transparency or the constitutional position, how transparent the constitutional position of the chief election commissioner can be made. So this all starts with selection committee. Who constitutes the selection committee? Recently, a case in 2023, Anup Barnwal versus Union of India case 2023 happened, where the Supreme Court said very clearly, using the Article 142. देखो 142 पे already UPSC has asked the question. Okay, 2019 prelims UPSC asked the question about Article 142 to issue directions for doing complete justice. This gives sweeping powers to the Supreme Court. Laid down that the Chief Election Commissioner and election commissioners, the selection committee will comprise of Prime Minister, Leader of Opposition, and Chief Justice of India. Judiciary wanted that the Chief Justice of India should also be a part of the selection committee. But then, to check that, Parliament passed this bill. The bill replaces the previous Election Commissions Act, and what it said that this bill basically, it included Prime Minister, okay, one cabinet minister and leader of opposition, not Chief Justice of India into it. So this had been the change, and right now what happens that the legislation is the jurisdiction of the Parliament, not of Supreme Court. Therefore, it may go for judicial review and anything else, but right now this is the selection committee, and from here the question can be asked into your examination. Also read from the static. This is how interlinkage has to be done with respect to the current affairs and the static. This is the election year, okay, the greatest festival of our democracy, and here Election Commission of India, certain controversies happened. So this topic you should studying very well from your static portion. How the Election Commission of India will be removed, what are the parameters behind it. Okay. Next topic is Press Registration of Periodicals Bill 2023. It basically repealed the colonial era law that Press and Registration of Books Act 1867. Just understand. Press reforms. Modern history में आप लोग पढ़ते जरूर होगे. Press reforms in India. How the Britishers tried to gag the press, to gag the dissent against the government. So here we found some reforms into it. What happened that this particular act, okay, it repealed books. You find this word books. It has separated the books from the periodicals, journals, or the newspapers. So here you have to understand that one thing is called as periodicals. Periodicals can be like newspapers. The Hindu, Indian Express you read, magazines, down to earth. So these are called as periodicals. Now these periodicals will be regulated by the press registration of the periodicals. It has not included books into it. Books को कौन देखता है? Ministry of Education. Human Resource Development's name has been changed as Ministry of Education. Not under this press and registration. So if the question is being formed, they will be talking about the books as well. Books को ये include नहीं कर रहे हैं. So what about the periodicals? Any comment that we are doing or any periodicals that is being released has to be registered with Press Registrar General. It is responsible for issuing registration certificates for all the periodicals. Even what comments we are doing, that also matters over here. The foreign journals or the foreign periodicals, foreign publications that are being reproduced in India need permission from Registrar General of India. So what certain changes have been done? Let's compare. Scope of regulation, previously it covers the books also. Now it excludes book administered by Ministry of Education. Previously filed declaration by printing press required before the district magistrate. Right now online intimation can happen. Online, digital India. Online also it can be intimated. Declaration by publisher of the periodicals required before district authority. Here Press Registrar General will be responsible for it. Criminalization. Jan Vishwas Amendment Bill has been passed, where a lot of offenses have been decriminalized. In line with that, you will understand here, previously it had severe penalties, imprisonment up to 6 months. Right now, substantially decriminalized and reduced penalties have been there. Okay. Punishment for violations have been reduced in certain cases. Cancellation or suspension authority, only district magistrate could do that. Now press registrar general. So what will happen, that press registrar general has been introduced with new powers. These powers we should understand, press registrar general becomes a very important authority going forward. Expulsion of lawmakers in India. The case of MP Mahua Moitra was there in the news because her login credentials for the Lok Sabha had been used from UAE 47 times from 2019 to 23, and the person who was using had connections, relatives, foreign nationals as well. That may lead to the breach of security, breach of national sensitive information. For that matter, okay, this was the news item, but question will come from what are the constitutional and legal basis for the expulsion of the sitting MPs. So constitutional as well as legal rules of the House basis. Constitutional basis of expulsion, MP found guilty of breach of privileges. So this is a clear-cut breach of privilege. Or contempt of the House, can be suspended from the House or face expulsion. So what happens at stage 1? We suspend the member, but then expulsion happens. Legal basis of suspension and expulsion: to ensure smooth proceedings of the House and maintain order, decorum, presiding officer of the House has the power to force a member to withdraw from the House. In cases of extreme misconduct, then suspension happens. Expel the member and find the person unfit for the membership. So these are the two things. So constitutional as well as legal basis are there for the expulsion of the members. Okay guys, so thank you. Keep working hard and keep revising the current affairs.